Ladies and gents, welcome back. We've all been putting on our lawyer hats, internet lawyer hats, these past few weeks, looking into this inquiry into the use of the Emergencies Act. Now, I've been confused about some of the things personally on how the law works. I'm a mechanic. Damn it, Jim, I'm a mechanic, not a doctor. So I thought I'd bring in a professional. And what I did was I reached out to Eva Chipiuk to come in and help explain a bit of what's going on here with the law. Eva, welcome back.
Thank you. Nice to be back.
So number one, the first one out the gates is a lot of people they're coming up for their testimony, and we're hearing what sounds like pleading the fifth. We hear them invoking some sort of thing in our charter or in the laws to not have to testify, or at least not to have prosecution based on what it is that they say under their testimony. How does that work? A lot of people confusing this with American law and the American Constitution, but how do our laws here in Canada work?
Yeah, so I could start with I think too many people were watching Law and Order and Suits and things of that nature. So in the States, you could plead the fifth, which I think we've all heard about. And what that means is you don't have to answer anything that will incriminate you in another proceeding. That's not how the law works in Canada. But what happens, or what we did, is that we requested that the commission subpoena all of our witnesses. And why we did that, because on a subpoena, so let me, back up a little bit. Like I said, you can't plead the fifth. So you have to answer any question. If you're at a trial or an inquiry such as this and you're under oath, you can't just say, I don't want to answer that because somebody might sue me because of that answer. So you just can't do that. So what we did is we asked, and the commission agreed to subpoena our witnesses because number one, two of the witnesses that we had, Chris Barber and Tamara Leach, are still, they have charges against them. So anything they were to say could have been used in the criminal trial. And so we said, no way. And also, we don't know if any police officers are going to go after any other of our witnesses and our clients. So we said this has to apply to all our clients that were involved in the protest, that you have to subpoena them. And what we did is invoke Section 5, which means they're coming under subpoena to answer questions, but anything used is protected by the charter for them on any criminal or civil suit outside. So anything they actually say cannot be used against them in another proceeding.
Wow. Okay.
I
So
hope that makes sense.
it makes sense to me. I hope it clarifies things for a lot of the people that are watching here. But basically, that it doesn't matter what they say in the testimony. Nobody can come after them based on the things that they say, except perjury, which is the exception that they make pretty clear there. And perjury being lying under oath. If you're caught lying under oath, there are serious consequences for that. But this leads into something that I just thought of as you're explaining this. During this hearing, we haven't been hearing a lot of what the hearing is for. The whole point of the inquiry is to find out justification for the use of the Emergencies Act. What we've been finding is, or hearing, at least what I speculate into what I'm hearing, is a lot of particular parties trying to build cases in other lawsuits that they have going. And how much of that can be used because of this protection?
Well, so I don't want to speculate who you're talking about, and I don't think it's appropriate for me to go there about other people's and lawyers' tactics and lawsuits. But I do have to agree with you, at least with respect to, and I'll just say it, Mr. Champ. Some of the questions I believe are more, pertinent to the lawsuit that he's filed, and that's the more appropriate venue for some of the grievances that he's bringing about, honking and nuisance to the Ottawa residents, with which all of our clients acknowledged, that's not what they came to Ottawa for. But he does have a 400 or $300 million lawsuit against these clients and others. We're not here on his lawsuit. We're here because, and apparently, there was a national security threat that caused the federal government to invoke the Emergencies Act.
Yeah, well, we've all been witnessing this and kind of taking a seat back and wondering why so much time is being wasted. Now, speaking of time being wasted or not being wasted, I noticed when during certain testimonies in cross-examination, some teams are just coming forward and saying, no, we have no questions for this individual. Is that a strategy, or is there a reason why you wouldn't, any particular party of standing wouldn't just at least ask some questions, even if they just something at all? I'm just curious.
Yeah. Well, there's we could talk about and look at a number of examples, but for example, the province of Alberta, they haven't really piped up too much when it had to do with local municipal politics and local police enforcement, because it's really not their area. And what kind of questions would they be asking the Ottawa Police Services or the counselor? So that totally makes sense to me. And I don't know if that's the party you were talking about with respect to, for example, our clients. Today we were hearing from Windsor and Coots protesters, and there really isn't much that there is to talk about, except for, did you see violence? Were you engaged in violence? What the national security threat, the CSIS Act requires for this national security threat to be invoked. And again, what are we here for? So, when we came in here, this really wasn't how I thought things would play out. I thought we would be talking a lot more about those aspects. What you've seen probably Brendan Miller do is he sometimes will just go directly to those questions and ask very specifically under the CSIS Act Section 2, did you experience or were you part of any of these requirements? And really, if you think about why we're here, that's all we need. So all of the other stuff is extra.
Yeah, it just seems like conjecture and people's opinions at this point, and a lot of wasting time, like I said. Now, other people are trying to waste time. We heard that Doug Ford was given a summons to appear. I'm not sure who summonsed him in this process, but he was successful in blocking it, in using a piece of legislation that's meant to save parliamentarians from being pulled away from voting for other reasons. I guess this rule applies. How did this happen? How did he get away with not having to appear?
Well, so that was the one part of it. And the second part, the jurisdiction, federal versus provincial. And it sounds like we're going to be hearing a lot more about that outside of this inquiry, because of how some of the premiers, for example, Alberta and Saskatchewan, are starting to take ownership of the province and saying the feds don't have the right to get involved in our provincial politics. So if you think of it that way, that's a little bit about what happened with Doug Ford. This is a federal matter. Doug Ford is not involved in federal politics or federal even issues of security. He's involved on a provincial level. So that was kind of, I wasn't surprised by the decision, I can tell you that. And to be honest, I really don't know exactly what Premier Ford would contribute at this stage to the proceeding. Like, we've heard from top OPP officers in Ontario. And I think that's who you want to be hearing this kind of evidence on, about whether or not, again, if we're looking at why we're here, about whether or not the Emergencies Act was justified, let's talk to intelligence officers. And we did. I don't really know what Premier Ford would contribute to that conversation.
Right. Well, we did see, and some evidence came out today in testimony about a conversation that he had, or a correspondence that he had with Justin Trudeau himself. And I immediately thought, oh, well, that puts him right in the line of fire where he would want to come in and testify and give his 2 cents or his testimony as evidence for why he either had nothing to do with it or had something to do with it. But he's been dragged into it already in evidence.
Well, yeah, and it was a conversation there with the Prime Minister, and just talking about this document, I've been quite surprised at how like without, not formal, people are talking to each other and they know everything's being transcribed, and I'm kind of assuming that if this was transcribed, the conversation was probably a little bit more loose. And so there's text, we've seen some of the notes taken by police officers, and I've been a little bit surprised about that, because anything that's written by these people can be subject to a FOIP request, and turns out it could be put on national television now in an inquiry. So honestly, a little bit surprised at some of the notes and the conversations that we're seeing.
Yeah.
But there
Well,
you go.
now
There
we know
was
what
some
kind of
interesting ideas.
bookends most people have these days. So.
Yeah, that's the one I was thinking of too.
Yeah, right. All right. Well, thanks, Eva, and thanks for the updates on what's happening in this inquiry. And where can people find you on social media?
Well, completely unprofessionally, you can find me on Twitter and TikTok now at Forever Eva 79. I did that well before I thought I'd be doing anything like this.
Oh, perfect. Well, I'll make sure the link is in the description down below. Thanks again for coming.
Pleasure.
And thanks for tuning in again to another update on the inquiry. This interesting thing that's happening in Canadian history right now. And well, I'll keep you posted on further updates. Tune in for that. Keep on trucking.